Hello everyone. Today we will discuss another topic under environmental studies and environmental laws. Today's topic is public participation and citizenhood provision under environment law. The list of topics to be covered here is introduction, environment legislation, environment impact assessment, public participation, and citizenhood provision. Environment is the wellspring of life on earth like water, air, soil, etc. and determines the presence, development, and improvement of humanity and all its activities. The concept of ecological protection and preservation is not new. The word environment relates to surroundings. It can be defined as anything which may be treated as covering the physical surroundings that are common to all of us, which includes air, space, land, water, plants, and wildlife. Some of the important environment legislations are Air Prevention and Control of Pollution Act 1981, Biological Diversity Act 2002, Environment Protection Act 1986, Forest Conservation Act 1980, Indian Forest Act 1927, National Green Tribunal Act 2010, Protection of Plant Varieties and Farmers' Right Act of 2001, Public Liability Insurance Act 1991, the Scheduled Tribes and Other Traditional Forest Dwellers Recognition of Forest Right Act 2006, Water Prevention and Control of Pollution Act 1974, Wildlife Protection Amendment Act 2002, Wildlife Protection Act 1972, Noise Pollution Rules, Hazardous Waste Handling and Management Act 1989. Environment Environment Impact Assessment or EIA can be defined as the study to predict the effect of a proposed activity project on the environment. It is a decision making tool. Environment Impact Assessment compares various alternatives for a project and seeks to identify the one which represents the best combination of economic and environmental cost and benefits. Environment Impact Assessment systematically examines both beneficial and adverse consequences of the project and ensures that these effects are taken into account during the project designing. It helps to identify possible environmental effects of the proposed project, proposes measures to mitigate adverse effects, and predicts whether there will be significant adverse environmental effects even after the mitigation is implemented. The purpose of AIA is not just to assess impacts and complete an environmental impact statement, it is to improve the quality of decisions. Through informing the public about the project, proponent can make environmentally sensitive decisions by being aware of a project's potential adverse impacts on the environment. Another purpose of environment impact assessment is to inform the public of the proposed project and its impacts. In this context, public participation provides crucial information. Through their participation in the project proponent will be able to take advantage of the information that citizens contribute concerning values, impacts, innovative solutions, and alternatives, which ultimately helps the proponent in the final decision making. Now, the concept related to public participation. Public participation is regarded as proper, fair conduct of democratic government in public decision making activities. It is widely accepted as a way to ensure that the project meets citizens' needs and are suitable to the affected public. The project carries more legitimacy and less hostility if potentially affected parties can influence the decision making process. The public participation in environmental decision making, and in particular in impact assessment, may lead to some benefits in these processes. As a result of public participation, the process of decision making up to and including the final decision becomes more transparent and legitimate. Public debate on proposed activities among all interested groups at an early stage of decision making may prevent or mitigate conflicts and adverse environmental consequences of the decisions with their impacts. The decision to participate must be genuine, otherwise, public participation becomes a procedural exercise rather than a substantive democratic process. Public involvement can be used to create a project that is more suitable to and accepted by the public. Suitability should depend on the public opinion and needs rather than the technical feasibility of the project. Public input can be crucial and valuable source of expertise before, during and after project planning and decision making. Now the concept related to citizen suit provision. We have already discussed this concept under an Water Act and Air Act. A citizen suit is a lawsuit by a private citizen to enforce a statute. Citizen suits are particularly common in the field of environmental law. It comes in three forms. The first form of citizen suit is a private citizen can bring a lawsuit against a citizen, corporation, or government body for engaging in conduct prohibited by the statute. It is against those act or conduct in which these persons or authorities have been engaged, and these particular acts are specifically prohibited by the law. Second type of citizen suit provision is a private citizen can bring a lawsuit against a government body for failing to perform a non-discretionary duty, which a government body is bound to do. They have not done it, then the private citizen can file a suit against them. The third type of citizen suit is analogous and to the common law tort of public nuisance. Citizen suit provision under the Environment Protection Act 1986. It says that until the enactment of the Environment Act, the power to prosecute under Indian environmental law belonged exclusively to the government. And the citizen suit provision in the Environment Act expands the concept of locus standi in the environmental prosecutions. Similar provisions allowing citizens' participation in the enforcement of pollution law are now found in Section 43 Clause 11 of the Air Act and Section 49 Clause 12 of the Water Act. And the citizen suit provision appears to give the public significant powers to enforce the Environment Act. Under Environment Protection Act 1986, Section 19 Clause 13 deals with the it says that it provides that any person, in addition to authorized government officials, may file a complaint with a court alleging an offence under the Act. However, the person must have given notice of not less than 60 days of the alleged offence and the intent to file a complaint with the government official authorized to make such complaints.